Very soon, it will be time for you to deliberate. In the interest to deliberate, in the interest of justice, and in the name of the people of the state of New York, I ask you to find the defendant guilty. And with those words, the prosecution concluded its closing arguments today. And as we head into tomorrow, where the jury will get the jury instructions and the jury will start to deliberate. Karen, it was an eventful day today with the defense's closing argument. It lasted about 2.5 hours. The prosecution's closing argument that I think went a little longer than perhaps we expected. They did tell the judge earlier that it was going to be about 4.5 hours, and I think they used all of that and perhaps a little bit more. As we're recording this, it is 8:08 p.m. East Coast time when these proceedings just wrapped up. It's 5:08 here on the West Coast. The trial will resume tomorrow at 10 a.m. East Coast, 7 a.m. Pacific. But a lot to discuss, Karen. Let me just throw it over to you before I give any of my commentary. People are here to see you, Karen. Karen, you worked at the district attorney's office for nearly 30 years. You were the number 2 at the Manhattan District Attorney's Office. You've given many closing arguments. You've been in Justice Merchan's courtroom before. You've done trials there. You were a leader in that office. So I want you to take us all through what went down today with the closing arguments. Maybe we start off, Karen, 30,000 foot level, right? And then maybe we then zoom in after kind of overall observations. Then we take it one at a time. The defense's closing argument, the defense went first, and the prosecution's closing argument, they went second. But let's start your overall observations from that 30,000 foot view, Karen. What'd you make of today?
My overall observation here is that the prosecution did a really, really good job in summations today. It was a very methodical, very plotting summation, which they needed to do. It's a complicated case. It's got 34 counts. It's a paper case. It's white collar. It's harder to understand than like a violent crime case, right? Everyone understands a murder or something like that. But, this is one that's a little bit complicated. So the prosecution took their time. Yes, they did a more than 5-hour summation. Some people were saying that was too long. They kept the jury almost 4 hours later than they normally would. The jury agreed to stay later, though. It shows how much they were really paying attention and how seriously they're taking this role. They agreed to stay until 8 p.m. They normally leave around 4:30 every single day. So I think everybody's taking it seriously and everybody's doing the job and really realizing the seriousness and the weight that sitting in judgment of any human being is, and potentially finding them guilty of a crime and convicting them. So I do think that the jury clearly is taking this seriously. By all accounts, people in the courtroom, they were there, they were watching, they were rapt with attention. And the prosecution did what they needed to do, which is take their time and methodically go through the evidence. I think Todd Blanche also went first because the New York civil procedure law says the defense goes first and then the prosecution goes second. It's unlike the feds where it's like a sandwich summation where first comes the prosecution, then the defense, then the prosecution gets to go again. This is the defense always goes first in every single case, and then the prosecution goes second. Like I said, it's part of the procedure, the New York criminal procedure law. It's just laid out like that. And they went for about 2.5 hours. And I would say that Todd Blanche, for most of his summation, frankly, I was surprised and frustrated, only just from a lawyer's standpoint that he was meandering. He wasn't making his points. There are some really good points to make here, and he wasn't making them. He made them at the end, finally, but he really didn't. I think there was a lot more he could have done, and he didn't do. But then the prosecution, I think they methodically really hit it out of the park.
So, Karen, what time does the jury actually start deliberating? Let's go there, and then we'll zoom in a little bit more on the defense summation and the prosecution summation. So what happens next? What can we expect to happen tomorrow? Is there any more kind of lawyering that needs to be done on the jury instructions? Does the jury come in right away? What goes down tomorrow?
So tomorrow, court starts at 10 a.m. Eastern, which is 30 minutes later than normal. I think the judge is having them come in a little bit later, given how late they stayed today. And there could be some housekeeping matters to do tomorrow. For example, the jury charge. The judge really has up until the moment right before he gives the charge to change it. And the one side or the other tonight might make a decision that they want it changed, that they want it, that they have an argument that they want to make. So that could happen. The other thing is the defense has not asked, but it's not too late. They still could asked for the lesser included offense to be added, which basically means there's the felony falsification of business records, but there's a lesser included misdemeanor falsification of business records. So in other words, if they find that the defense, if they find that the defendant falsified business records, but not necessarily with that added element to aid or conceal or commit another crime, that bumps it up to a felony. They could determine, they could say, okay, you know what, we don't want an all or nothing felony or not guilty. We want to compromise, give them another option of the misdemeanor. And I think the defense could ask for it here. They would also have to waive the statute of limitations because the statute of limitations, which is 2 years in New York on a misdemeanor, because that's run. It's not something the prosecution could ask for example, in this case. And it's not something that the defense could ask for unless they were to waive the statute. So again, they have up until right before the jury gets the case to ask for that, and before they get the charge. So they haven't asked for it yet. No one's even mentioned it. So I doubt they will, but I mention it because it's something that that's possible. So that's the deal for tomorrow. They'll come in and the judge will do what's called charge the jury, which means the judge will read the judge's instructions. And the 80% of the judge's charge is standard that a judge would read in any criminal trial. It's, what the burden of proof is, what the presumption of innocence is, the defendant doesn't have to testify, how to evaluate credibility, just regular things that apply to all cases. And then the judge will get to the 20% or 25% that applies specifically to this case, which is the elements of falsification of business records, as well as any other specific things that apply to this case, like don't hold it against the defendant has the right not to testify, and you're not to consider that sort of thing. So that the judge will do that. The judge estimates that his charge will take about an hour. Every time, as a prosecutor, every time I heard the judge's charge, I get this pit in my stomach, because beyond a reasonable doubt is a high burden. It's the hardest burden of proof. It's the highest one in our judicial system, and look, it's just hard. I got a lot of convictions, but every time I heard that, like I said, I'd kind of panic and think, oh my God, hopefully how am I going to convince 12 people that met my burden beyond a reasonable doubt when was the last time 12 people could agree on where to go to a movie or where to go to dinner, right? So it was always hard to hear that, but then comes the deliberation, and it's nail biting. It's hard, and they go back and they go into a black box essentially, and you don't get any window into what's going on. And you just sit there and you wait. Sometimes judges make you wait in the courtroom. Sometimes judges let you wait outside. Sometimes they let you go back to your desk as long as you're within a few minutes, 10 minutes away from court with a phone call. That's okay. So who knows what the judge is going to do here? I always stayed around the courtroom because, first of all, I can't do anything else. I'm petrified and you're just racked with nerves, but also because if a lot comes up during deliberations, jurors might have questions. They will send notes out. They could potentially want readback, et cetera. And I just would want to be there for all of it.
So Karen, what time tomorrow do we expect deliberations to officially start? The morning? Do you think it gets pushed to the afternoon after instructions? When would you guess that it starts?
I would guess that it would start at 11 o'clock. I think 11:30 maybe. I think by 11:30 the jury will be deliberating, and my guess is very quickly you'll get a buzzer with a note saying we'd like to see the physical evidence, unless the parties all agree that all physical evidence goes in with them. Parties don't always. Defense attorneys don't always agree to that because they don't want them seeing all the evidence and make them ask for it, make them ask for certain things. So I can imagine a scenario where Trump's lawyers don't want to send all the evidence in, and they wait until you get that first note asking for the evidence, and then, and you just go from there.
Well, Karen, the prosecution certainly went over each piece of evidence, piece by piece, over 4 hours, 4.5 plus hours. That's what they estimated their time was, but it just felt like a very long time. But from what I hear, the jury remained engaged. The jury still seemed interested. There was some self-deprecating humor by the prosecutor as well. And I think that kept the jurors' attention. We'll talk more about the prosecutor's summation in a moment, but let's talk about Todd Blanche, Karen, Donald Trump's lawyer, in the defense summation, making some, I think, strange arguments and then some improper arguments for which he was admonished outside of the presence of the jury. Now, Todd Blanche, one of the things that we thought he was going to spend a lot of time talking about was the absence of Alan Weisselberg and that missing witness. But he talked about that for a little bit, but he was also emphasizing the absence of Don Jr. and Eric, and the fact that the prosecution didn't call Don Jr. and Eric. Now, this was the first day where Don Jr. was in court with Tiffany, and Lara Trump was there as well. And it seemed a little bit like Trump's lawyer throwing the kids under the bus and saying, well, they would have been involved in the criminal conspiracy also, but where were they? You didn't see them there. So I found that to be interesting or odd. You had Todd Blanche denying that there was ever sex between Stormy Daniels and Trump, which seems like a way to lose a lot of credibility. And I heard that some of the jurors were like, huh, and making some faces when he said that. Also, Karen, the fact that Jeff McConney, Donald Trump's former controller and Trump's former CFO, Alan Weisselberg, did not destroy the smoking gun evidence and that it still existed. Those handwritten notes on the bank statements of Michael Cohen. The defense lawyers tried to say, well, if he was really guilty, why didn't they destroy the evidence? I don't know, because that would be another crime. And then that led the prosecution at the end to basically say, it's almost, I think this is what the prosecutor said in his closing, it's almost laughable what they were trying to make you believe. Like it's unfathomable, but there they did it, that they were trying to still act like this wasn't a reimbursement when there's all of the documents that clearly say reimbursement, 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 reimbursement. And he's like, I'm shocked that they would go up here and actually say that to you, but that's what they're going with, I guess. How strange is that? So I thought the prosecution capitalized on that. And then, Karen, there was that other moment where the defense lawyers mentioned to the jury about, you have to be very careful about putting a man in prison, referring to putting Trump in prison, which violates not just a pretrial order, but a pretrial order that exists in all criminal cases. That's a big no-no. The jury's not involved in the sentencing process. So by talking about the jury being involved in sentencing was problematic, to which Trump's lawyers were admonished outside the presence of the jury. And there was a curative instruction that was given. That's my high-level summary of what went down. What do you make of the defense's summation, Karen?
Yeah, look, I mean, again, so first of all, just the defense's entire strategy here. Frankly, the thing that worried me the most about this trial was Michael Cohen, right? If a skilled defense attorney can really make a dent in his credibility, and Todd Blanche barely made a dent. When else do you have someone who has conviction for lying, and who has lied so many different times for Donald Trump, but so many different times, and then had hundreds of hours of statements about his testimony right here on the Midas Touch Network, right? A skilled defense attorney would be able to really, I think, call into question his credibility, and he was almost untouched. There was what maybe one moment, two moments that people said there was some they made some headway, but it was easily explainable, first of all, and turned out to be much ado about nothing. So I was really surprised about that, just overall in the trial, that was the case. But the summation, similarly, I think really just missed some opportunities. If again, I just can't believe that they didn't make more out of Michael Cohen and how this all relies on Michael Cohen. Instead, they talked about whether or not there was sex with Stormy Daniels. Who cares, right? It has nothing to do with this case. He paid off the doorman that turned out to be false, and Karen McDougal and Stormy Daniels too. It doesn't. The payoff happened whether these things happened or not. It's just about the motive, right? So it just was a strange summation in that regard for Todd Blanchard. I'm not saying, look, I'm glad he didn't do those things. I'm glad he was not as effective. It just surprised me, frankly, that he didn't, I think, do some. He took on things he didn't need to take on, and he missed opportunities that as a defense attorney he should have done and could have done. So, the whole thing about the missing witnesses, about Don Jr. and Eric, where were they? I think that backfires big time for him. Because if I'm the jury, I'm going to be like, those are your kids. If they had something to say, to say that would help Dad, they'd be the first ones up there on the witness stand. It almost kind of proves that, like, they don't have that evidence, right? Same thing with Weisselberg and Schiller. Like, I think on balance, that backfires big time, and that you hold that against the defense, not the prosecution, because these are all people who would be loyal to Trump. So that was also a strange argument that I just don't think helped at all. And like I said, I think they wasted a lot of time on Stormy Daniels and did not matter. And the other thing that I thought was interesting too is he made a lot of arguments that there was no crime here. Right? Like, he just said, oh, there's no crime. This is perfectly fine. Influencing an election is part of a democracy. And, it's a legal expense. If it were me, I would have said, okay, there might be a crime. A crime might have occurred, but my client had nothing to do with it. That was all Cohen, Michael Cohen trying to curry favor and do things on his own. And he went rogue. But to say there's no crime, again, that to me was a strange argument. I'm not really sure why they did that. And I'm just looking at my notes, which is why I'm looking down, because I took a lot of notes about some of the things I just thought were so strange. And I just so I do think that there were aspects of his summation, like I said, at the end in particular, that were somewhat effective, but I do think a lot of it was strange and ineffective and may actually even backfire.
Karen, what do you make of the moment where Todd Blanche was admonished by Justice Merchan for talking about prison?
Look, so what that is, what he basically said was something like, is this really worth sending someone to prison for something like this? Or would you send someone to prison on the word of Michael Cohen? Something like that. I don't remember exactly what it was, but that's like a red line that every lawyer, especially someone who used to be a prosecutor like Todd Blanche, knows. That's totally inappropriate for the jury to consider anything involving punishment. He knows that was intentional. That was not a mistake on his part. He's trying to garner sympathy with the jury and trying to play or prey on their sympathies and hope that at least one of them will feel sorry for him and say, I wouldn't want to trust somebody to go to, the word of Michael Cohen to send someone to prison. But again, totally inappropriate. That caused the judge actually ended up giving a curative instruction right then and there. Like, in other words, it was so serious. It was so serious about what he did, that he didn't wait until later to give a curative instruction when he gave all his other curative instructions. He actually interrupted summations to give that instruction and basically said, that you're not to consider anything involving punishment. That's up to the judge. And he even added in there one extra thing, which was that, and in this case, it's not even required. Prison's not required. And that was like an added thing that I think he felt he needed to do because it was so inappropriate.
Karen, let's talk about the closing argument by the prosecution. Joshua Steinglass from the prosecution gave the closing. Mr. Steinglass, right? And so the opening was by Matt Colangelo, but to have Steinglass do it here, he's obviously with the district attorney's office, has been with the district attorney's office. What do you make of the length of it? Was it too long? Was it necessary to be that length? That's some things that people are talking about. It was certainly meticulous. He certainly seemed to keep the jury's attention, but maybe go through it all, but also at a high level, do you think it was too long based on everything you know about that office?
So look, Josh Steinglass is one of the most serious, best of the best attorneys that the prosecutor's office has. He has the title senior trial counsel. It's one of the most prestigious, if not the most prestigious title there. He's very experienced. And if he thought he needed 5 hours, he needed 5 hours, right? And the thing is, look, I know a lot of people were saying it was too long, that it was boring, but prosecutors are of a totally different role than defense attorneys. Prosecutors don't view their role as entertainment or theatrics or showy. Prosecutors are in some ways, you want to be boring. You're not there to entertain the jury. You're there to methodically take them through all of your evidence. If you have something to say, you want to say it, and you want to. If you're repetitive, that's kind of a good thing because because juries, people don't retain a lot of information necessarily, and if you have an important point to make, someone might have missed it the first time you said it, but the fourth time you say it, if you say it 4 different times in 20 different ways, that's kind of a big deal, and it's really a good way to handle it. So I'm not concerned that he went too long. First of all, everyone in that courtroom reported that the jury was just in rapture. They were just like, their attention was just absolutely focused. They're taking this seriously. The judge asked over and over again whether they're willing to stay, and they said yes. I mean, if they were beleaguered or in some way fatigued, they would have said, no, we want to go home. They didn't do that. And this is too important. And I'm proud of Josh Steinglass for taking the time he needed to put all this together. Look, if this was a crime that occurred in, 5 seconds, right? A robbery on a dark alley, and it was a 5-second crime, and he went for 4 or 5 hours, I would say that's way too long. But this is, if you recall, the relationship between Cohen and Trump dated back to 2006. So there was a lot of things that Cohen did for Trump during that time, and there's a lot of history and context that Steinglass needed to paint that picture for the jury so they would understand why Cohen would do the things that he would do for Donald Trump, why these individuals, who's who, what they did. And the crime occurred over the period of many months. And there were lots of elements and aspects to this crime. There were phone calls that were made. There were text messages preceding the phone calls. There were witnesses who testified about how business is normally done. There were book excerpts, and what does that mean? And why were those introduced into evidence, and tweets that showed certain things that were going on at the time. So I think in a case like this that is so complicated and has so many layers and took place over the course of many months, I do think 5 hours over this was what, a 21, 22 trial days, this trial. I don't think that's too long. And like I said, if Josh felt like he needed that, this was not an off the cuff summation. He prepared it. And I know this not because I have any inside information, nor have I spoken to him, but I know him, and he has worked on this summation the entire trial. He worked on it. He's been thinking summation the entire trial. Everything he put into evidence, there's this there's this kind of saying, ABC, always be closing. You're always closing your entire trial. Everything you say is going to be argued in your summation. Every piece of evidence you put in is going to be something that you're going to argue on summation. It's the most important part of the case is the summation, because it's where you tie it all together. Otherwise, you're just putting phone records into evidence and no one knows why, or you're putting documents into evidence and no one knows the significance. The summation is where you tie all that together and you say, this is what this means. This is what, Stormy is the motive. That's why we called her to the stand, right? They don't pay $130,000 because there's a photo of someone next to Donald Trump on the golf course. They don't pay twice that and gross it up to make it look like income, for someone just because they were in a photo together. Stormy Daniels is the motive. And so that's why that photo was put into evidence. That's why Stormy Daniels testified. And if they didn't get to sum up on it, you wouldn't know that. Or, Cohen paid the price for his role in this scheme. Of course, he's angry about it, right? So otherwise, he just looks like an angry, disgruntled person. But this is why now they know why, and now they see why that is. Of course he is, and they put it into context, or the fact that they called out inconsistencies in the Trump defense attorney narrative, and basically said, look, you can call him, on the one hand, they called Michael Cohen a thief, and on the other hand, they call him, this was a reimbursement, but you can't, it's not both, right? That's an internally inconsistent argument. Again, something that might not have been obvious had they not had a summation. So the entire thing was like that. I thought two really important points they brought out that was that, look, Trump himself does not have to make the false entry as long as he caused it to be made, these false entries. And so, as long as he caused the reimbursement scheme that was spelled out on exhibits 35 and 36 in Weisselberg and Cohen's handwriting, as long as he caused it, that's enough. That was a really important point that I think they made very, very successfully. And then the funny thing too is, they used seemingly negative things about Cohen to their favor. So another way that they did that was they said, look, is there any doubt that Cohen is a self-promoter, right? Every cross-examination, the whole cross-examination of him was he's a self-promoter. Or, Hope Hicks, he's a self-promoter, right? Everyone knows that's what he does. And so the prosecution used that to their advantage. And they said, yeah, so therefore it's unlikely that he wouldn't have told Trump of what he was doing. He's not the kind of guy who's just going to go pay it out of the goodness of his own heart. He wants to take credit. He wants to get credit. So it's unlikely that he would not have told Trump. And P.S., on October 26th, there were two phone calls from Cohen to Trump, and the timestamp on those phone calls is right before the wire that was sent from Michael Cohen to Keith Davidson, right? That was the wire, the $130,000 payment to Stormy's lawyer. So right then and there, they're like, look, of course that's what those phone calls were about. And don't forget, that was 2 days after that other phone call that the defense was like, oh, well, that was about being harassed by a 14-year-old. What Josh Steinglass did there was say, who cares about the October 24th phone call? That was, it almost doesn't matter, because on the 26th, you know what that phone call was about, because it was right before the wire was sent. And so again, it's just I'm just giving you a couple of highlights that I thought were really, really good, because if I went on for 5 hours, I don't think the 21,000 people who are watching this live with us and commenting, I don't think that they would appreciate if I went on as long as Steinglass. So those are just a few highlights.
I think they would, Karen. I want to say that there is such a hunger out there for the evidence and the facts and what's actually happening in the courtroom and what the real process and procedure is. And you know that office better than anyone. I think these days of the media just pushing BS narratives and trying to jam that down the cable networks to us, those days are gone. This is the age of the Midas Touch network, of Legal AF, of people like Karen Friedman, Agnifilo leading the coverage based on experience, based on data that is here right now, right here today. Karen, before we go today, any last thoughts about the way today went down? Anything else you want to let LAFers know what to expect as we head into tomorrow?
Look, I just think we have to respect the jury and the jury system no matter what happens, right? There's so many different possibilities here. There's full conviction, full acquittal, full hang, and then there's some combination of any of those things. And don't expect a quick verdict. I think the jury could be out all week. I think might not even have a verdict by Friday. They're going to go through this methodically. They're going to go through these arguments in detail. They're going to go through the evidence in detail. And I think I just have so much respect for the jury system. So I think we have to all be very supportive of whatever happens, and hopefully, tonight. I always say summations are always so hard because there's 3 summations that a prosecutor always give. There's the prosecution, or there's the summation that you meant to give, right? The one you prepared all weekend and you intended to give. And then there's the summation that you actually gave. And then the third summation is the one you're going to go home tonight and you're going to beat yourself up and say, this is the summation I wish I had given. So of course, you're going to think of things that you forgot or that you missed or that you wish you had said differently. And that's always the hardest part. And, but I think this was just a huge case that the prosecution put together, and I give them a lot of credit. And but now it's up to the jury.
Karen, one of our viewers writes, KFA, you keep talking, I'll keep listening. Someone else writes, I would listen to KFA for 5 hours straight. I echo that. I agree with that, although we'll end this at the 30-minute mark, and you and I will continue our coverage of the Trump with all breaking news developments. I want to thank all of the Midas Mighty, all the legal AFers for making the Midas Touch Network the #1 place across all digital media in the world to get your news, not just about the Trump criminal trial, but about all politics. I think we were beating the NBA during playoff week, Apple during a product launch, Vogue during the Met Gala, based on the coverage that you're leading, KFA. So I want to thank you for that, and thank all of you, the Midas Mighty out there, because without this community, without you watching and sharing this network with others and sharing the facts, none of this would be possible. Karen, myself, Michael Popak, the whole team here is so grateful for all of you listening and watching this right now. Make sure you're subscribed to our YouTube channel. It is free to subscribe. You may think you are subscribed because you get a lot of our videos, but just double check. It's free to hit that subscribe button. Check that out. Also, it would be very helpful to Legal AF if you subscribed on the audio podcast as well. Wherever you get audio podcasts, just search Legal AF and hit subscribe there as well. It really helps with the algorithm there, and we upload these videos and other content on the audio feed. Thank you all so much for watching our continuing coverage, and of course, thank you, KFA, for leading our coverage. We appreciate it.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.